Welcome to another installment of Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we're going to be discussing the sheer amount of money that's being left by employees on the table upon termination. And I understand that this is not based on empirical evidence because there is really not the empirical evidence that is out there that employers would share as to how much they are effectively lowballing, underpaying their former employees as they're terminated. And it may well be that you were terminated and permanently laid off from a company that pays a substantial amount of money that would otherwise be owing to their employees. But that unfortunately appears to be the exception and not the norm. But once again, it is hard for anybody individually to tell what it is because these matters are always bound up in confidentiality agreements, privacy aspects, and the employers are not out there looking to share this information with whether it's the public or people of interest. Instead, what we're really led to operate on is the basis of the information that we obtain in our professional practices. That being said, it would appear, and it makes sense, that a lot of employers do lowball their employees when they are relieved from their work. And the economics of it are such that it makes sense to be effectively lowballing because so many of the employees will be simply accepting the terms that are initially offered. They might have other financial considerations that make it difficult to accept anything else. And they simply sign off on whatever is being offered. They might go to the internet and find some incomplete information on the internet and be satisfied with it and move on. They might start calling lawyers, and certain lawyers will charge exorbitant fees simply to review the information. And that turns off a lot of former employees from doing anything further. Meanwhile, there appears to be a whole realm of demand letter practice where you demand stuff, you don't really get into details, and you don't have a clear, concise strategy as to how you're going to pursue stuff beyond the demand letters. And the employers realize this, and whether they give a bit more following the demand letter or not, they recognize that the demand letter by itself is largely not sufficient to justify responding back with anything of a substantial increase. So the only way to be dealing with this is to force the situation to litigation. And the number of matters that actually get initiated into litigation, in my estimation, is very small. And even then, the process is oftentimes designed to work in favor of the employers if the right strategy is not deployed. So that makes it a very big challenge. In turn, what you find is that there's a lot of lowballing, a lot of underpayments, and there's a lot of money that's being left on the table by employees when they get fired and terminated from their current job. It might not be the case with yourself. You might have a justified and fully due amount. But then again, given experience, that is probably not the case. And then the other aspect becomes strategy. Is there an effective strategy to be deployed to allow you to obtain that money that you are entitled to? And that's always a challenging thing and something you have to consider. But until you've approached the right lawyer and you've discussed the specifics, you've provided the documentation, you will not be able to ascertain whether or not there is the basis to effectively approach your former employer and demand a more appropriate form of compensation and not leave that money on the table. And that is why you need to speak to the right professionals and make the right determinations with the knowledge in front of you. And that is what is critical. Hopefully that provides you some guidance, and we thank you.